is Mike Douglas, and I'm the chair of the Ethics and Malpractice Law for BHBA. I'm delighted to introduce our speaker today, Christian Puzder. Christian is the co-founder and CEO of Casefriend, a legal technology platform built for workers' comp defense and lien resolution firms. Casefriend integrates case management, workflow automation, and AI-driven tools into a single environment with, importantly, attorney oversight embedded directly into the technology. Christian also serves as on the Washington University Law AI Advisory Board. So, Christian, thank you for joining us, and let's go ahead and get started.
Thank you, Mike. Appreciate that introduction. I'm going to go ahead and share my screen now. All right, let's make sure everyone can you see my screen, Mike?
Yes.
Excellent. Cool. Thank you for the introduction. As Mike said, I'm Christian Puzder, CEO of Casefriend. Before founding and running Casefriend, I spent many years practicing law. I actually graduated from Pepperdine and then practiced law in St. Louis, and then moved into Westlaw and worked on the Westlaw Next development team before coming to Casefriend about 7 or 8 years ago. And in my experience, when I started practicing law, e-discovery was the new thing. I saw many years of development at Westlaw. And what's really struck me now is that there's no technology that's evolved as fast for lawyers as AI has. And the adoption rate for AI really is incredible in legal tech. There's kind of a cliche that lawyers are slow to adopt technology. That just isn't the case with AI. And while AI is ubiquitous and easily accessible to everyone, delivering powerful tools for attorneys, because it's developing so quick, it's being used in a highly ungoverned manner. And that's the core of my presentation today, and why we're here is to talk about what I'm coining the John Connor rule for professional AI use under COPRAC, the ABA rules, and other state bars. If we remember the Terminator 1 and 2, the Terminator was the perfect autonomous AI system. It was human, kind of indistinguishable other than for, Arnold's unique appearance. You couldn't tell that it wasn't human. It was incredibly efficient at its task and completely aligned with all of its objectives. But as we learned, it lacked humanity, it lacked judgment, it had no accountability. The Terminator would complete its job no matter who got hurt. And then in the second movie, we were introduced to a child, John Connor. John Connor had human judgment, John Connor had human oversight, and although he was kind of a troublemaker, he would validate his actions before taking them. And this image is really what we need for responsible AI use in the legal practice and what California's COPRAC guidance offers. And that John Connor rule is simple, that AI really can only act for the benefit of the attorney users when human review is involved. So no matter how confident, correct, fast, efficient the response or an AI tool appears, the attorney really needs to provide that level of validation. Before getting into COPRAC, let's talk about the roles that attorneys play and AI plays in the legal field. First, AI as a tool is fast. It can assist. Like a first-year associate, it can help, and it's not designed necessarily to destroy, but it assists, it's fast, and it can pull in a vast amount of information rather quickly. The attorney role, which sits next to AI, is the attorney with the experience, the knowledge, the skills that can decide, that can make the actions, that can determine whether or not an analysis is correct, if facts are correct. And this bifurcation of roles is really what's powerful and makes sure that accountability never leaves the lawyer. That's not something that's negotiable. It's part of the California Rules of Professional Conduct, the ABA model rules, the Formal Opinion 512, and even other states are beginning to enact rules and guidance that set out this kind of bifurcation of roles to make sure that accountability never leaves the attorney. Before we get into COPRAC, I want to identify really the scale of the issue here. I checked yesterday on the Charlatan AI hallucination cases database, and begun in June of 2023, they've tracked 1,063 cases where attorneys have been sanctioned for using AI with hallucinations. And if you go through these cases and you read these, what you come out with is this blunt statement that AI efficiency does not equal competence. It does not equal legal competence. The output, just delivering work product that looks shiny and good and reads well, does not necessarily mean it's accurate. And automating tasks, while it feels good, while it feels fast, does not allow you to comply with governance and with the ethical and framework applied by the ABA and the COPRAC guidance and CAL. This legal technology, this AI legal technology really is, as I said earlier, is advancing faster than any other in our profession. At Westlaw, I saw that it took years, not just to build and deploy technology, but also achieve adoption. We spent years going out to law firms explaining to them why Westlaw Next was the good tool to use. But with AI, these tools are free. There's no contract to sign. You can go out into Copilot, into Harvey, and other AI tools and dump legal information into them and get an answer real quickly, which means there's no training, there's no guardrails, there's no governance, and that can generate a real risk. Don't be fooled by the speed at which this technology can deliver it. It can build a false sense of security. What we need to keep in mind as lawyers is that professional responsibility will always outweigh technical capabilities. So with that background, let's jump into some key aspects of the recent COPRAC framework. California gives us guidance on how to build those guardrails to use AI responsibly and within the rules and avoid sanctions. The COPRAC doesn't, as we know, doesn't create the rules, but in 2023, in November of 2023, they came out with some AI guidance, and that was recently updated, I believe, in last month in May to address some of the agentic AI, that's been growing and being released in the recent years. This is something I'll repeat, and really, I think it's the foundational principle of the COPRAC guidance is that efficiency does not replace professional responsibility. Just because you can do something fast doesn't mean it's done correctly within the rules of professional conduct. And so they've got 5 core requirements I really want to focus on today. The first is competence. We as attorneys need to understand the tools that we use. Again, these are growing and being adopted at lightning speed. The advancements that are being made kind of are exponential in growth. So it's critical that attorneys keep up to speed with those changes and make sure that they understand how this AI tool can be used. Communication doesn't change when you have AI. Communication with clients must be clear, and so that your clients understand how you're using these tools. Because a lot of clients can go out and use these tools themselves. They can get in trouble for doing it, but they understand what these tools are, and they may understand the capabilities better than you as an attorney do. I think the most important guidance is the confidentiality. There's really nothing more important to an attorney than our privilege with our clients, and understanding the immense risk that comes with using AI and delivering your client's information into AI is something that needs to really be understood and respected while you're using these great tools. Candor to the tribunal. It's a fancy little phrase, but basically it means that what you deliver to the court must be accurate, and not only substantively accurate, but as we'll find out, COPRAC now institutes a mandatory final human check gate before filing anything. And finally, supervision kind of wraps all of the guidance into one good discussion where managerial attorneys, supervisory attorneys, partners really are responsible for how their subordinates use AI, no different than they would be on how their subordinates use a library or Westlaw. But there's a certain amount of responsibility, and there are ways to enforce that responsibility within the firm that we'll explore here. So let's get into the first piece of guidance from COPRAC, which is the competence, that verification layer. Verify, verify, verify. I'll say it throughout the presentation because lawyers always remain responsible for their work product, the outputs, the decisions, the filings, all of that remains with AI. So even though AI may look wonderful and return a letter, an email, a filing that reads like a seasoned attorney wrote it, whoever requested that work product from the AI must review it. The rule I have here and that I give to my attorney customers when they use our AI system is to treat our AI system, the questions you ask it and the responses, as if you're working with a summer associate. And every day that you use AI is that summer associate's first day. We wouldn't, if a summer associate came into our firm in a shiny suit and was very glib with their language and knew what to say, when we gave them a task, we would still make sure that they understood the context of the case, how to do the research. And when they provided that work product to us, we would review it before we did anything with it. The same should be said with AI. We wouldn't just submit a filing that a first day summer associate wrote without reviewing it, but yet there are some attorneys that have found that they do that with AI, and they've faced competence violations and at least 1,063 sanctions orders as of yesterday. So in order to comply with this rule, and just a general rule of thumb is to treat AI as that summer associate, that first year who maybe is working while they study for the bar, or they just passed the bar. They just got back from their vacation after taking the bar, and we need to make sure to give them the guardrails for the research and review all of their work product before we do anything with it externally. Secondly, kind of follows along that order and really more tees it up is communication. And this disclosure of communication to the client depends on whether or not the AI use materially affects the decision-making process. Of course, there's kind of, the word may is in there, and as attorneys, we talk about, well, what does that mean? It depends. Really, if your AI use is significantly affecting the representation, it's helping you make decisions, it's helping you build strategy, then that disclosure to your client is going to be required. With disclosure, what you want to do, I think that there's when I practiced, it was employment defense. So I'm very familiar with these, discrimination policies. And this really reminds me of that. The AI use policy, the communication with the client must be communicated. So put it into your engagement letter. Just put a one-sentence comment in your engagement letter about the fact that you're going to use AI tools, maybe even what those AI tools are. That you're going to use it for research and drafting to the extent you're going to use AI tools so that your clients are fully informed. Because if your client comes back and says, don't use AI, don't use this particular AI tool, that must be strictly adhered to because your client restrictions absolutely matter. We'll find out later, and as I talk about traceability, anything that's done electronically, assume the judge and the client can discover and use against you if they want to. Just like we as attorneys, when we have a litigation matter, we can use anything we discover against the other side. All of this is tracked and traceable. So we want to make sure that we're adhering to our client requirements and communicating with them our policies and how we're using AI. The next piece of guidance I want to talk about really is it's my personal favorite, if I can have a favorite of these, because it seems so on its face clear as to what the requirement is. Um, but that there's no expectation of privacy with an AI tool. So that's a general rule of thumb because you've got a giant computer system where the purpose of the computer system is to take information that's fed in and apply it to information that people are using later. So if you take a client's medical records and you upload it into a third-party AI tool, you don't know how that third-party AI tool is using your client's medical records. And that could be that could be multiple violations. If you have some attorney confidences that you're putting into ChatGPT and ChatGPT doesn't protect that information or uses that information to train other models, you're at a big risk of losing that confidence and exposing your client's information to an AI tool. So what we want to do with confidentiality and make sure we're protecting our client information is to understand really the terms of service of your AI tools. Although these tools are built into the applications we're using, our company uses Microsoft Office. Copilot is everywhere. It's easy to use. We understand the terms of service on how to use Copilot and what we can and can't share with Copilot. As an attorney representing a client, if you're using a third-party AI tool, make sure you understand how that AI tool uses your client's information and even your questions. Clients are using these tools, and as we know from a recent decision that using a client using ChatGPT to get legal advice doesn't have any expectation of privacy there. And so the opposition can, in discovery, retrieve those questions, retrieve the responses, and then use it in litigation. That's a very real risk for pro se clients, and it's also a very real risk for attorneys if you're using those tools. So for the confidentiality guidance, the practical tip here really is read the terms of service. They can be painful for our company, CaseFriend. They're publicly available on how we use AI. I think there are going to be a lot more companies that start to use that in the legal tech world. We want to look for language such as we will use your inputs to train our models. That's an immediate red flag not to use that tool because you'll lose that confidentiality. So as you're adopting agentic AI, as you're adopting Gen AI or any kind of AI system, make sure that you fully understand how that AI system is going to use your information to make their system more powerful. Because whether it's OpenAI or Harvey or Claude or CaseFriend, to a certain extent, we put CaseFriend off to the side, but those companies, especially, Claude and Harvey, they generate revenue from the amount of data that they can process. So we want to make sure if we use those powerful, really good tools, that we understand how that information is being preserved, who can access it, and whether or not they're using it to train models. Going from confidentiality, kind of down the timeline, we've got candor to the tribunal. Really, for this guidance, the way to think about this is that candor to the tribunal cannot be delegated to AI. That means that legal tasks can be completed by the attorney, cannot be delegated to AI. While you technically can go into an AI system and say, draft me a motion to dismiss based on blah, 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 go to bed, the technology exists where when you wake up, it's been drafted and it's been filed. A candor to the tribunal wants us to not do that and puts in some guardrails there to make sure we don't. Meaning all of the authorities, the facts, everything in the case must be verified by the attorney. It can't be misstated or taken out of context. AI systems, I used to refer to them as scaled up plagiarism because what they do is they take all of the language that's been put into their system and then they just reorder all that language to come up with an answer to the question you asked. That's really, really simplified. Don't get me wrong, the technology is incredible and it's very, very powerful, but essentially that's how those models learn is they take the history from the documents that have been uploaded to generate an answer. And that just means you can have hallucinations, things can be taken out of context, they can be incorrect. So making sure that you verify means that you've got accuracy of the law, the facts, the context, everything that's needed in whatever the output is from the AI system. Because that obligation for verification and accuracy has always belonged to the attorney and always will. The final part of this guidance is no autonomous filing. In my illustration, I mentioned technically you can go to bed and have an AI system draft a motion and file it. But at least for COPRAC, the guidance is AI must not be permitted to autonomously file documents. My customers actually can get very frustrated with this because in work comp defense, there's a particular process that the technology is intentionally manual because the DWC wants people to go through that process. They don't want machines to go through that process. And there's a couple reasons for that. One is the courts don't want an attorney who doesn't have the resources to be disadvantaged by an attorney who does have the resources. And secondly, this is that final gate where courts put in place to make sure that a person knows what's being filed. If a person has to actually file the document, then the responsibility is on that person filing to know what they're filing so the court can come back and say, hey, you're actually responsible for this. So keep that in mind that the obligations of validation belong to the lawyer, and courts, especially in California, are putting these in place. For the verification, what you can do to make sure that what you're filing is accurate is really what we've been doing since we were in our first semester 1L legal research and writing. Shepardize, key cite, verify citations, pinpoint cites, read the pinpoint cites, make sure that everything is accurate. And so that you're making representations that are to the court that are accurate and correct. And next, to kind of wrap everything up for the COPRAC guidance part of my presentation is the managerial lawyers and how the COPRAC guidance really applies to managerial attorneys, supervisory attorneys, partners. As you're managing subordinates and non-lawyers to do legal work, the responsibility to manage how they use AI stays with you. And I mentioned my HR background and policies earlier. I kind of spoke a little bit too soon. This is really where that policy for your firm comes into effect. We've got policies and trainings, we've got anti-sexual harassment, anti-discrimination policies. Firms need policies about AI. There are digital natives out there who they've grown up with technology and they're perfectly comfortable holding one of these everywhere they go. But that doesn't necessarily mean that they're competent with the tools. It just means that they're competent holding it and using it. In my experience with legal tech, kind of separating generations, there's the older generation where the cliche is they don't know how to use tech, and you've got the younger generation and they know how to use tech. Really, that's not true. The lines are blurred. There are a lot of younger attorneys who are comfortable with tech, but misuse it because they're so comfortable with it. And misusing technology because you're comfortable with it can introduce a significant amount of risk. So as a managerial attorney, as a supervisory attorney, how you can comply with this is to create a policy, a very simple one-page AI policy that states which AI tools are approved for attorneys to use, how they're approved, the kind of information that your firm will allow your attorneys to put into the AI system, and how the output will be used along with the verification. So you've got the tools to use, what to ask the tools, what output can be used, and the verification. In a simple one-page policy that's reviewed by the managing attorney, at your biannual, your quarterly firm meetings, making sure that everyone's up to speed on it and is aware of it, so that that's what your firm can use as really kind of as a defense. Use that policy, keep it in place, make sure all of your attorneys, really, especially your younger attorneys, the older attorneys, we are very skeptical about a lot of things, especially technology, because we're not as comfortable with it. The younger attorneys who grew up holding phones, having smartwatches, they're comfortable with it, and they're really just they're at risk for misusing technology and creating sanctionable actions just as much as an older attorney who kind of, misuses it inadvertently. So in daily practice, I want to get back to what I stated at the beginning about treating AI as your first year associate. To implement this guidance, the rules of professional conduct, the ABA rules, these are some pretty straightforward tips about treating AI kind of as a non-lawyer assistant. We want to review all the outputs before use, confirming that their accuracy, because really AI generated work is not self-validating. Understand the limitations of AI. With my work at Westlaw, I saw an evolution of natural language in legal research. So Westlaw back in the day was very scientific and sterile. You had to choose a database. You had to know what the database was, where the answer existed, choose that database, and then compose a Boolean search with slashes and numbers and quotes. And really, the librarians at larger firms became experts at that scientific skill. As we developed Westlaw Next, what we wanted to do was make it easier for attorneys to use. So we implemented natural language in the search, and then gave back to the user highly relevant search results, where the attorney could ask a question: what is the standard of summary judgment in Missouri? And then Westlaw Next would present that answer. AI takes it an evolutionary step from that, and you can ask a natural language question and get a natural language result that sounds like a person actually wrote it. And what AI is doing is it's taking all of the results and it's forming sentences that sound really, really good. And that can lull us into a false sense of security about the accuracy. And the limitations of that are that it's only going to answer in that shiny language the specific question that's asked using the information that it has. And that just means that validation, that accuracy, that cycle of validating, reviewing, editing, revising is absolutely inherent within an AI system. I love AI. I think it's absolutely fantastic. I use it every single day in a variety of different ways, but I never accept personally, and I would give this as guidance to you and to my attorney users, that even if AI's first answer is stunning and beautiful, that does not mean that every following result afterwards will be stunning and beautiful. It can give you 10 great results, and then the 11th will be absolute trash. So as long as we keep up our attorney questioning everything ability and making sure that we're validating all of the results, and preventing those unauthorized practice risks, keeping attorneys within those guardrails, we're going to really mitigate the risks involved with using AI. What can happen without this oversight that COPRAC is providing? And really, COPRAC, California are the tip of the spear for this guidance. They're actually doing, I think, an incredible job articulating some really, really great guidance for attorneys. But we've got 1,000 cases that can tell us exactly what happens when attorneys don't follow this guidance, and the errors in those cases can help us develop the actual guidance to be used. Two cases that stick out for me is Mata v. Avankia, where an attorney used ChatGPT in a personal injury case, but there were fake sites used in that case, so that case was dismissed very early on. Park v. Kim, and actually that Mata case reminds me of early e-discovery, where people were just using electronic information without considering how that fit into the rules of discovery. Mata is a great early example of an attorney that's using AI without thinking about how that technology fits into the rules of professional responsibility. Park v. Kim stands out for me because it's a really brutal, devastating statement made by the court. Here, the attorney cited to a non-existent case in an appellate brief, and when the court asked for a copy of that case, apparently she generated a fake judgment. And this language is devastating, and it's really probably on the far end of the spectrum. Maybe it doesn't happen often, but it certainly can happen when these rules and the guidance from COPRAC aren't followed. That's the court said that the counsel did not read or otherwise confirm the validity of these non-existent decisions, and that behavior falls well below the basic obligations of counsel. If I ever delivered anything to the court and this was the court's response, I would probably have left the practice of law and gone back to managing fast food restaurants, because it's crushing for me to read this because it's such a devastating statement. And on top of it, the court ordered the attorney to deliver that opinion to her client, which really is, again, it's at the far end of the spectrum. But it's one of those things that you get lulled in the false sense of security as you're using this really cool technology, and it exposes the risks of what can happen if you don't have checks along the way. So why did this happen to Mata, in Mata and in the Kim case and the other 1,060 some odd cases that are in the hallucination database? It's pretty straightforward if you go through these decisions. Attorneys are relying on hallucinated facts, feeling that the results are always correct. There's incomplete context. AI doesn't understand your client's representation. They don't understand your firm policies. It doesn't understand a lot of that, the kind of soft skills about being an attorney. And if attorneys neglect that blind spot from AI, a risk increases. The false confidence signals that false sense of security because the output is so beautiful, it's well written, it's structured well, it feels filing ready. That can lull us into that false confidence and deliver something to the court that doesn't allow us to have candor with the tribunal and get us in trouble. And then, of course, the one that kind of shocks me every time I read one, where an attorney turns in a brief, a filing, that they failed to verify the sources. I'm the first to admit I might not have been the best law student at Pepperdine, but I certainly learned, verify your sources as you're going through and presenting things to the court. The best way to avoid that is apply that John Connor rule. Bring the humanity in, question everything, use the skepticism that we as attorneys learn in law school and that we're taught and that we always bring wherever we go, whether it's in our personal life and reviewing a mortgage, or my attorney customers dealing with me, questioning everything about what we're doing. Inherently, attorneys question everything and we're skeptical. So apply that to what AI does. There's nothing wrong with it. It's the best thing to do. It brings humanity, it brings authorship, it brings attorneyness into what AI's output. And so it can help us avoid these missteps that are commonly occurring within the legal practice and causing attorneys to be sanctioned. Again, human review every single time. Think about John Connor with everything that the attorney wanted to do, or the attorney, everything the Terminator wanted to do. John Connor applied that human review to every single action and even told the Terminator why, gave the justification why. And we should give that justification to ourselves as we make sure we don't fall into that false sense of security. I'd like to look at some practical applications of AI right now because they're numerous within legal. There isn't one AI tool or one legal workflow for AI. There are multiple, and AI can affect them in very different ways, like legal drafting. If you use Word, you've got Copilot built into Word. I think Harvey just released an add-in for Word. All of these AI systems can generate documents. And they do a really fantastic job. But as attorneys, you got to review it and approve it. Case summaries, depositions, nothing reviews a deposition and can summarize a deposition faster than an AI system. But we got to review it. Before we take it to the bank, we got to review it and make sure it's correct. I have a customer of mine, in work comp defense, it's a high volume business. So they receive many depositions, some taken by other law firms and other attorneys. He uses our system to review those depositions, but he makes sure he goes back and verifies that what is being output is actually in that deposition before he speaks to his client to review the case. Similarly, in work comp defense medical records, it's a high volume case. Every case will come in with hundreds, thousands of pages of medical records. AI systems can review those documents at lightning fast speed to find conflicting medical reports, conflicting diagnoses, conflicting prescriptions, and advise the attorney on it. In fact, for attorneys, I think this is the coolest thing for AI because it really balances the playing field for plaintiffs and defense attorneys. Defense really can't send over 50 million documents to a plaintiff's attorney that's a solo with maybe one assistant and say, hi, I just buried you in discovery. Good luck. Let's settle. Because now that plaintiff attorney can take that discovery, feed it into an AI system, and start asking questions immediately. Yet the attorney still needs to review it. So while the attorney has to spend the time being a lawyer, the part that's sped up, the part that AI really benefits the attorney is being able to scan 50 million, 100,000, 2,000 documents almost instantly. So that's a really huge benefit, whether it's medical records or a big pile of discovery. AI can be used to review those records, but the attorney still has to slow down, make sure that everything is accurate, everything is verified before taking an action on it. Email is really, really risky with AI because email doesn't exist in your case file. Within our product, it does, but most products, email exists over here and your case exists kind of over here. And so your AI with an email doesn't have any contextual relevance to your cases. It can be a really good tool to scan your inbox and find action items, compose responses, compose new emails. Very, very powerful, fast, efficient tool, but yet every email should be reviewed by the attorney before it goes out if AI generated. Outlook actually now, if you use Copilot to draft or revise an email, Outlook will not allow you to send it until you read a statement that says AI can make mistakes. Make sure you review this before you send it, something like that. So Microsoft is actually even implementing that final human review gate for all of its users, but especially attorneys who use Outlook to make sure that you're following that guidance and you've got that last human review gate. And finally, a practical application for AI and this John Connor rule are the intake workflows. And this is where revenue is generated for law firms. Because now with AI, law firms can bring in more cases in a day because you can automate that intake process. You can automate setting up the client. You can automate the document ingestion, the document extraction. So many of those manual, repetitive, mundane, unbillable tasks, that can be delegated to AI. But that output still needs to be reviewed by a person. I hear my customers now, they say, can't you just do all this and then deliver to me this final product? Technically, we can do it, but we build in stopgaps to make sure that as a 5,000 page new file referral comes in, if a staff member is organizing those documents, that staff member must approve every single document so that that person is accountable and the attorney can review it and then approve not only the AI work, but also the staff member work. So that John Connor rule of verification, reviewing, the theme there for all 5 of these different use cases is AI generates, whether it's work product, answers, questions about depositions, medical records, the attorney must review and the attorney must approve before taking any particular action on that case for the client or for the law firm. Frequently, we as technologists are asked about kind of the future of AI. Where do you see AI going? What's the next step? Taking the John Connor rule, the COPRAC guidance, I think we've got a really good vision that the governance layer is what's important and what law firms and attorneys are going to start needing to implement in their firms and what providers are going to need to build into their technology architecture. Everything done electronically is traceable. That's good and it's bad. For criminals, it's bad because we know where you were if you got a cell phone. For attorneys who need to audit their subordinates, it's great because we can trace how an attorney uses AI and we can create that kind of chain of custody, that provenance. So when that answer is used, we know exactly who created it or who approved the answer, what tool they used, what prompt they used, when they did it. To make sure that is defensible, because really your malpractice carriers are going to, if they haven't asked you already, they're going to start asking you, "What's your AI policy? Can I see a copy of it?" And a shrug of the shoulders response really isn't going to cut it with your malpractice carrier. They're going to economically make you feel the fact that you don't have a good AI policy for your attorneys. So making sure that you've got this governance that's built in with your policies, forced human validation, traceability, auditability is really important for your malpractice carriers, and especially case integration. Case integration is whether or not your AI system has unfettered access to everything at your firm. This is something that really needs to be addressed by providers in my industry, in the legal tech industry, because AI that has access to every email sent by a managing partner and the manager of the firm not only has case emails, which are relevant, but you're also going to have those HR emails. You're going to have emails about there's cake in the break room or Sally's on vacation. But what you want to avoid with an AI system are emails between 2 attorneys that discuss the performance of another attorney or the performance of a client. If those aren't segregated, isolated by your AI system, they become part of the case intelligence. And that's another risk point that you have. So policies and technologies which build stopgaps in their technology architecture and in their policy architecture that focus AI systems on the legally substantive documents and emails are ones that are going to avoid the most risk. If I can simplify it, a good model of governance is that every AI drafted document, motion, brief, whatever it is, the model being used, the prompt, the question, the reviewing attorney are all logged with that document because that's an audit trail and that's defensible. I want to take a step back now and kind of talk about the paradigm shift that we're seeing in legal practice. My dad was a lawyer. I grew up going to the office with him on Saturday mornings, and he practiced under the old model. That's We'd go to the library, he'd take a book off the shelf, he'd copy some pages, he'd cut something out, tape it to a yellow legal pad, write around it with his black barrel warrior pencil, and then put it in his secretary's basket. And I guess she did something with it. As a kid, I didn't know what she did. When I became a lawyer, I learned that that's that manual process. And I came up in 2002, and there were still some attorneys doing that. Technology has developed over the past 25 years, and grouping it all together, you can now automate all of that with just a few clicks, where AI can go out and generate everything, and lawyers just skim it, and they don't even put it in their secretary's hopper. They just send it off. That's where the risk lies. So you can go from that very slow, methodical human, where human verifies every step in the old model, and you can transition through that Gen AI model where there's no human validation to a much more accountable way to practice law, where AI accelerates work, technology accelerates work, but attorneys oversee and validate all of the information output by AI. I think that's a really good place for attorneys to be and start being in 2026 and in the future, and have that fulfilled with the governance models we just spoke about, and building it into the firm policy and building it into the architecture. Because we've all heard it before, AI is not going to replace attorneys. I build AI models for attorneys to use, and I'll tell you, they'll never replace attorneys. There's a couple of reasons why. Some are philosophical, like the attorney is the apprenticeship model, and you need to train attorneys to work for you. One, that's how you make more money. The more people you have billing, the more revenue you're generating. And so you can't stop hiring associates in place of AI, because you're going to kill your revenue model. You're just going to kill that whole profession of attorneys. Even if the technology was there to do it, which I don't believe it is, and I don't believe it ever will be, because AI is built on the history of knowledge. And once we start cutting off humans who are building that knowledge, the AI will never get smarter. So if you think about the practice of law historically, and I kind of don't want to get too far afield here, but it's really relevant to the discussion, is that the practice of law is precedential, and we build on what people before us wrote and those decisions. And once you cut that off, you no longer grow your area of law, you no longer grow your intelligence, and AI will kind of cease to grow in its intelligence. But AI is a tool. And if people continue to add legal reasoning into public opinions and the public square, you can use AI to grow to be smarter, and so that attorneys who use that tool will outperform those who don't. It's going to be something that every attorney must use, but they have to use it in that governed way. Mentioned earlier, clients are using ChatGPT. They expect the speed, they expect the accountability. They can go out to ChatGPT, ask a question, and go to court, and then find out quickly they can't do that because the court's going to expose all their private information. So they want to come to the attorney who has the skill, the knowledge, the experience, the judgment, the responsibility, the accountability to take all the information from the client, use AI to best defend them ethically, responsibly, and using, again, their best judgment and their experience on how to handle those matters. Faster is fantastic. At Casefriend, we're using AI to not only develop new features, we're using AI to build new features, and it is months faster to bring something to market using AI, but the risk is so great, whether it's product development or defending a client in litigation. So faster is great, but it's not safer. Smarter is not accountable. Again, to close, only attorneys provide that judgment, the knowledge, the skills, the expertise. Apply all of that. Apply the questioning, the skepticism to everything that AI does, and you'll always avoid those kind of professional responsibility pitfalls that we keep tracking in that charlatan database. So as I wrap up, I want to save a few minutes for questions. Uh, my challenge to you, to my attorney customers, to all attorneys is in that age of AI, be John Connor. Intentionally introduce human judgment, impose oversight, and require validation before action. This technology is absolutely incredible. Attorneys should use it, but they should use it responsibly. Use it and use that COPRAC framework with governance, verification, and accountability. Because when something goes wrong, which it very well can, the court, the state bar, your clients, your malpractice carriers, they're going to go after you, the attorney. They're not going to go after the AI vendor. Because as COPRAC shows us, as the ABA rules show us, accountability never leaves the lawyer. At this point, I guess I can turn it over to the Bar Association to see if there are any questions I can answer for anyone.
All right, so Christian, it actually looks like we have quite a few questions. In the beginning of the presentation, someone doesn't sound that bad. They were wanting to confirm the ethics opinion number that you cited in the beginning was at 512.
The ABA?
I believe
I think it was,
so.
yeah, it was the ABA Ethics Opinion 512. That was recent, end of last year.
All right, and then I have a one question here. AI already passes state bar exams at a higher rate than the average graduate law student. How soon do you feel it would be equal or better than the average bar attorney in terms of quality of average legal advice?
Oh, when do I think that will happen? I don't know if it will actually ever breach the threshold for what a human can provide, because the humans will always have more soft information than an AI system will. It can sound good, it can pull in all the authority that it's aware of, but I don't necessarily think it's going to eclipse human judgment. I think it will feel that it eclipses human judgment, but I don't think I actually might be in the minority here, but I don't think it will ever breach that threshold. Again, going back to what I said kind of philosophically, is that AI can only use the history of information that's ever been created. Um, if that information, where that information stops, that's all that AI can pull from. A person can pull from context, not only knowledge context, but geographic context and things that might not be available to that specific AI tool. They'll get close. It will feel close, but I don't think it will actually ever eclipse it. That's my hot take.
All right. And then let's see, I have another one from Larry here. Discovery, is there any example of a subpoena successfully recovering AI data? Are you asking for a cup of water that has been poured into the ocean?
Is there an example of AI that, can you restate the question again?
Yeah. Is there an example of a subpoena successfully recovering AI data?
I don't know offhand. I know that there are cases where pro se clients have used AI and that AI data has been discovered by the opposition, has had to been turned over. I'll have to take a look and get back to the group if I can.
And then how do you manage attorneys' use of AI in the firm when each attorney has a different level of understanding of how technology works and competency or comfort with using it? Especially with AI, people have very different levels of understanding, and it's difficult for managers to accurately assess what their staff does or doesn't know.
Yeah, that's a great question. I know I touched on it in the presentation, and I can restate it here. Set up specific guardrails. So have someone at your firm, whether it's an attorney or a staff member, who becomes kind of the AI expert, the subject matter expert for AI, and who can recommend to the firm all the tools that should be used and how to use them. And then have that person work with the firm to build a policy that directs people on how to use it. Because that policy can be the protection layer later on down the road, but can also be the instruction layer for how attorneys should use AI. And then continually train on it, update it, have that subject matter expert at your firm review the policy at a regular basis and keep that person accountable to make sure the firm is using the best tools, the most secure tools, and in the best way. So create the policy, train on the policy, and enforce the policy. And just like any other HR policy, if it's not followed, then it really becomes just the responsibility of that the attorney that kind of went off on their own direction.
And let's see, to what extent is Westlaw's site check feature, where you load your document for cite and quote checking in AI system versus some of the older technological methods that are more reliable and like a word comparison function character by character?
Oh, how does the Westlaw function compare?
Let's see, to what extent is where
I'm a big Westlaw fan. Having worked for Westlaw and know the guys that and gals that run those products, there's really no one better in the industry. So I think the tools that they're coming out with are fantastic tools. But I would always caution, make sure that whatever the Westlaw, I think their co-counsel feature, what it's called now, outputs, still apply that human verification. That team is very methodical, and that team will deliver to you all of the authority that they relied on when the system develops the answer. So definitely still take the step to site check it. Again, I'm a little biased on this, but I think that they're fantastic, probably at the top of the mountain in the industry for what they're doing.
All right. And then I have another question. How will new attorneys learn the practice and the ability to oversee AI without having the same kind of experience building apprentices we used to have?
Keep the apprenticeship model. Focus on the apprenticeship model. If you're a partner, if you're an attorney who's been practicing for a while, it's so important to bring up those young attorneys to teach them the foundational aspects of legal research and legal writing and litigation and negotiation, and then deploy those AI tools on top of that foundational knowledge. And attorneys that keep that apprenticeship model going and are using AI, I think are going to outperform attorneys that kind of deviate from that and minimize the importance of the apprenticeship model.
And then I have another one here. What is the pro per subpoena case citation?
Which one? Oh, for the pro se who use ChatGPT. I don't have that off the top of my head, but can I get back to you on that one and you can send it to the group?
Yeah, I can I can forward that question over, then we can provide that.
Yep.
Alrighty, it looks like that's it for questions. Here, do you have any other closing remarks that you'd like to mention to our audience?
No, just thank you to everyone who joined. I think you've got the slides, and if anyone wants to reach out to me directly with any questions or anything, feel free. All my contact information is public.
All right, great. Thank you, Christian. This concludes today's presentation. Thank you again, Christian, for an amazing presentation today, and thank you to our audience for joining us today. Have a great day, everybody.
I appreciate it. Thank you.